Where do we go from this? Uganda court upholds eviction of pastoralists in Lamwo district, citing rights violations. Gulu, Uganda. The High Court of Uganda, sitting in Gulu, has dismissed a significant human rights application brought by 11 pastoralists, largely upholding a controversial decision by local leaders in Lamwo district to evict them and their cattle. The pastoralists are the ones known as the Balaalo. The ruling delivered by Justice George Okello found that while the applicants, often referred to as Balaalo, have a constitutional right to settle anywhere in Uganda, their presence and practices in Lamwo have violated the fundamental rights of the host community. The heart of the dispute, land use and conflicting rights. The case, which is civil in nature, a civil misc, application number 150 of 2021, pitted 11 pastoralists, that is Timbigamba Simon and others, against local leaders and councils in Panabek County, Lamwo district. The applicants claimed they had lawfully acquired land through rent or purchase for pastoralism, and that the respondents were illegally attempting to evict them, violating their rights to property and freedom of movement. They also sought damages for defamation, arguing that being called Balaalo, a term they found derogatory, implying nomadic herdsmen, spies, rapists, and guns owners, was stigmatizing, according to the Balaalo. The respondents, including the Prime Minister of Palabet Chibdo and various local council chairpersons, contended that the pastoralists' arrival had disrupted traditional agricultural practices, destroyed crops and water sources, and caused social unrest. They asserted that the pastoralists had not followed customary land acquisition procedures in an area predominantly governed by customary land tenure system. The respondents also pointed to presidential directives ordering Balaalo out of the Acholi sub-region. Court's findings: no property rights, justified eviction. Justice Okello meticulously examined each applicant's claim to land. He found that most applicants had entered into hire agreements or partnerships rather than acquiring full property rights or interest in the land. The court clarified that such agreements created contractual rights, not property rights or proprietary rights, meaning there was no violation of their right to property under Article 26 of the Constitution. The judge also highlighted significant inconsistencies in some of the applicants' documents regarding land size and signatures. Crucially, the court recognized the applicant's constitutional right to move and settle freely within Uganda under Article 29(2)(a). However, it emphasized that this right is not absolute and must be exercised without infringing on the rights of others or the public interest. The judge accepted the respondents' evidence of widespread crop destruction, damage to water sources, and a fundamental shift in land use from traditional peasant farming to large-scale pastoralism. These actions, the court found, violated several constitutional rights of the Lamwo community, including right to life and livelihood under Article 22(1). And secondly, right to property under Article 26 due to destruction of crops and land. Thirdly, right to enjoy, practice, profess, maintain and promote culture and tradition under Article 37 due to the disruption of agricultural practices. Economic rights under Article 40 impacting lawful occupation and business. Proportional response and dismissal of claims were done. Justice Okello concluded that the local leaders were justified in intervening. He held that the limitation of the pastoralist right was proportionate, necessary, acceptable, and justifiable in a free and democratic society, aligning with the public interest as per Article 43, 1 and 2C of the Constitution. The court noted that the measures taken by the respondents, such as requiring the situation of pastoralists and coordinating with security committees, aimed at minimal impairment of rights. The court specifically dismissed the applicant's claims for the first one, violation of property rights, as no such rights were established. Secondly, defamation, deeming it a common law taught incorrectly brought under human rights enforcement action, requiring proper pleading and proof in a separate legal suit. Thirdly, general damages and permanent injunction. Then, fourthly, the allocation of a legal eviction, as the applicants had been given extended periods to vacate. In a significant observation, the judge also declared that any customary law purporting to grant clans or families the power to annul land transactions without court interventions would be null and void, being inconsistent with the Ugandan constitution. Each side was ordered to bear its own cost, with a specific note that the applicant's counsel would not recover costs from their clients due to their failure to file written submissions as directed by the court. The ruling underscores the delicate balance between individual rights and community interest, particularly in matters of land use and cultural preservation in Uganda. At Acholi Prohibitive, we have stood to give voice and cover land news and updates and activism, and we have also got a lot of legal threats that we are handling. Stay subscribed as we weather the storm together. Thank you.